Aaron.
Yeah.
Why didn't you say it the first time I said Aaron?
Because it's pronounced Aaron?
You done messed up, Aaron!
Aaron is here, everyone. It's not me who done messed up this time. It is Scientology who done messed up. And Danny Masterson done messed up. Guys, the judge's ruling in the lawsuit against Danny Masterson, David Miscavige, and the Church of Scientology in the harassment lawsuit that was brought. I'm just generally calling it a harassment lawsuit. Harassment, intimidation, stalking, fair game, all sorts of stuff. The lawsuit that was brought by Danny Masterson's victims, not only the victims that he was charged with, but also some of the other victims who testified that he was not charged with, and even some of the victims who didn't even testify in the second trial, and some of the victims' spouses have sued Scientology and Danny Masterson and David Miscavige as an individual for the stalking, harassment, fair game, intimidation, and all sorts of stuff that they were subjected to since coming forward again in, I want to say 2016. God, it seems like 2016 was so long ago now, but I really do think that's the time period that we're talking about. The judge's ruling in the case is the worst possible ruling he could have made for Scientology. This is the ruling. We did a video about the hearing that was done a few days ago on this subject. He finally published his ruling. He ruled 100% against Scientology on all matters in the anti-slap motion. One of the reasons, now anti-slap for you normies, I'm a normie too, but I'm picking up things as we go here. An anti-slap lawsuit is a lawsuit that you file in response to a lawsuit, or it's a motion that you file in response to a lawsuit when you're basically saying, Your Honor, I am being sued. It's a frivolous lawsuit, and I'm being sued for constitutionally protected activity. This is unacceptable, and you need to throw away the lawsuit or throw away certain parts of the lawsuit. Scientology filed an anti-slap against all of these people who had been victimized by David Miscavige, Scientology, and Danny Masterson. And in essence, they're saying, but they're suing us for protected activity. This is our constitutionally protected activity to stalk and harass and intimidate and do all these terrible things to these people. It's constitutionally protected. Okay. The judge threw it all out and dressed them down. I've gone through, it's a 20-page ruling. I've isolated certain sections that I'm going to share with you. I'm going to keep this video as short as possible, but I have certain sections and I'm going to read those sections. One of the interesting things about this is when you file an anti-slap, if you win, the other side has to pay all of your attorney's costs, or you can ask it and it will be approved. If you lose completely, the other side, you have to pay the other side's attorney's costs, as long as the other side expresses in advance their intention to recoup attorney's costs. And the plaintiffs in this lawsuit, the Jane Does, the other Jane Does, the spouses, they expressed up front, we are going to get attorney's fees. When we win this, we're taking attorney's fees. And they have won it, which means every step Scientology takes from here on out to appeal this ruling, and Scientology will appeal it to the state level, they will appeal it to the Supreme Court level. Every addition, and Scientology is going to do the appeals just for the sake of dragging it out and delaying. But every step Scientology takes to appeal this from here on out, the other side gets to recoup all attorney's costs. So that's pretty amazing. All right, let me see. I got my notes here of what I want to share with you, and I have the ruling here. By the way, I think before I forget, I have uploaded this document to Google Drive, and right now, so that I don't risk forgetting later, I'm going to go into this video, and in the video description, I'm going to put the link here. Judge's final ruling in anti-slap. I'll just call it Judge's final anti-slap ruling. Okay. So if you want to see the full document, you can just go look in the video description. Now I won't forget. Okay. This is it, guys. Final ruling This was just entered in yesterday. Special motion to strike certain allegations and corresponding causes of action from the first amended complaint. We're going to jump down to page 5 here. And actually, we might go even further. Yeah, we're actually going to jump all the way down to page 11. All right. Let's have a little fun with this. Okay. No, we're going to start with Jenny Weinman. All right, here we go. Allegations pertaining to Weinman, Jenny Weinman, and institutional defendants. I'm going to zoom in on this even more if I can. Jenny Weinman is a Scientologist. She was Danny Masterson's publicist. Let's just see what the judge has to say about this. Prior to the LAPD investigation becoming public in March 2017, plaintiffs allege that Danny Masterson's publicist, Jenny Weinman, engaged in steps to deter plaintiff Bixler from going public with her allegations. First, by attempting to dissuade Bixler from reporting her claims, and second, trying to convince Bixler that Danny Masterson could not have committed rape if the two were in a relationship. Plaintiffs allege that the second allegation echoed the words institutional defendants had previously made to Bixler in attempting to dissuade her from going public with her accusations. You know, institutional defendants, guys, really just means Scientology. So that's what I'm going to say instead. Plaintiffs allege that Jenny Weinman similarly endeavored to get Jane Doe 1 to retract her allegations against Danny Masterson and not to pursue any claims. Okay, we're going to jump forward. Allegations pertaining to Kendrick Moxon. Kendrick Moxon is a Scientologist, an OT8, and he is an attorney, and he handles some legal matters for Scientology. The 2004 letter from Danny Masterson via Mr. Kendrick Moxon to Jane Doe 1 likewise fails step 2 because it was purportedly a private apology to Jane Doe 1, as evidenced by the allegation that she was not allowed to keep the letter. There is also no indication that Mr. Moxon's statement to Jane Doe 1 that someone would contact her to broker a meeting with Danny Masterson was intended to involve the parties outside of Danny Masterson, Jane Doe 1, and their attorneys. Curiously, defendants made no effort to preserve evidence or develop argument in their moving papers or in oral argument to challenge these statements. By the way, guys, when it refers to step 2, he's just continuing to refer to the various criteria that a complaint has to meet in order to what's the word? To comply with the standards required for anti-SLAPP. It has to be protected, constitutionally protected activity that someone's trying to sue you to keep you from participating in. And then there was a component here about it being public interest. The communication activity is something of a public interest, and that's why the judge is pointing out these were private affairs. So this doesn't even fall under the domain, doesn't meet the criteria, the eligibility for anti-SLAPP. Okay, allegations pertaining to Urbanati. Now, if my memory is correct, it's Ilaria Urbanati is a name that we heard a lot in the Danny Masterson trial. So let's see. Allegations pertaining to Ilaria Urbanati. The statements alleged between Ilaria Urbanati and Jane Doe 2 did not contribute to a public discourse on an issue of public interest either. While this conversation allegedly occurred at a grocery store, there are no facts suggesting that Ilaria Urbanati intended to otherwise involve the public. In addition, this was a conversation between former roommates, Ilaria Urbanati and Jane Doe's number 2, regarding offense that occurred years earlier that commenced after Ilaria Urbanati invited Jane Doe 2 to join her for an evening out with Danny Masterson. Defendant's sole argument is that because celebrities are involved, the public interest requirements are satisfied. Once again, defendants attempt to collapse the 2-step film on test in 1 step. While discussing public figures, Hollywood actors Leah Remini and Danny Masterson might arguably implicate a prurient, I have never seen that word in my life, prurient. All right, guys, you get to see here while I look up that word. Prurient definition. Prurient, having or encouraging an excessive interest in sexual matters. Jesus, is that the right word? Is that the right word? Okay, sorry, I don't know. While discussing public figures, Hollywood actors Leah Remini and Danny Masterson might arguably implicate a prurient public interest. Such a private conversation in context does not come close to making the necessary public discourse nexus. Celebrity status on its own is not sufficient to render anything the defendant says or does subject to anti-SLAPP protections. All righty then. Okay, let's take a look at allegations pertaining to Miscavige and Mooney. Now, you guys might be thinking he's misspelling Miscavige. No, there is someone named Michelle Miscavige, and this is Vanessa Mooney. Vanessa Mooney has become kind of a famous person in the women's fashion space. Does she make purses? I forget, but I think does Vanessa Mooney, does she have a clothing line, a purse line or something? Anyway, she's a well-known Scientology person. Okay, allegations pertaining to Miscavige and Mooney. Michelle Miscavige and Vanessa Mooney. All right, efforts by Michelle Miscavige and Vanessa Mooney to dissuade BS from speaking with police or corroborating Jane Doe 1 is a closer call. This activity is alleged to have occurred after Jane Doe 1 contacted the police the second time to report Danny Masterson, and about the same time as LAPD's investigation became public. Still, other than alleging that Miscavige is an agent of the defendants, there is nothing in the first amended complaint or the evidence presented by defendants indicating who Miscavige is, her relationship with BS, the location of the interaction, or any other factors that provide insight into the context of the contact. Vanessa Mooney's communication with BS suffers from the same contextual deficiencies. There's nothing about the context of the allegations that suggest that it was anything more than private attempts to deter BS from supporting Jane Doe 1. In the absence of these contextual clues, the contacts are too remotely connected to the public conversation about those issues to merit protection under the catch-all provision. And again, that relates to the anti-SLAPP motion. As such, defendants have failed in their burden to demonstrate the necessary closeness or any functional relationship between the challenged conduct and any public interest. Okay, let's see. I do find this next paragraph interesting. Miscavige's contact with a reporter, however, is different. In context, communicating with a reporter to get one's version of events is a clear attempt to influence the public narrative in favor of Danny Masterson after serious allegations have surfaced. While plaintiff argues that such efforts further public disinformation of Masterson, the court is not able to make a normative judgment on which speech it should favor, that is, whose version is true. At this stage, the only question is, does the conduct further public discourse on an issue of public concern? The answer to this question as to this communication is in the affirmative. In other words, this conduct contributes to the public discussion of an issue of public concern. In sum, the speech alleged in paragraph 175, lines 5 through 6 of the first amended complaint sufficiently satisfies step 2 of film on. Okay, I want you to hear this next paragraph as well. Allegations pertaining to social media posts. Here, the court agrees it is self-evident that the online postings both implicated and were connected to an issue of public concern. As such, defendants have met their burden for purposes of prong 1 by demonstrating that the speech was made in connection with an issue of public interest. Now, you might go, what are they talking about with these public posts? Okay, well, check this out. Defendants contend that plaintiffs cannot satisfy the elements for the offenses. Defendants also assert that the speech and conduct was made by individual Scientologists: Heather Seidler, Virginia McGregor, Michelle Miscavige, Kathy Gold, and unknown social media posters who are neither named defendants nor defendants' agents. Plaintiffs respond that they have met their prima facie, I always not sure if I pronounced that, prima facie burden. Plaintiffs also assert that they have sufficiently shown agency based on conduct and circumstances. And in any event, they will develop such evidence in discovery. Okay, here's why I wanted to just read you him mentioning these other social media posts. He's talking about, he mentions certain individuals by name, but then he says other social media posts. I just want to take the opportunity to comment on a Scientologist named Ingrid, who was tweeting, literally calling on all Scientologists in the Los Angeles area to spit on the Jane Does. The tweets basically said, "We work in all walks of life. We live in Los Angeles," literally calling all Scientologists to spit on the Jane Does when they saw them. And then Scientology's on one of their online Twitter hate group accounts, the Stand League, seemingly could not get a hold of Ingrid privately to say, stop putting that on Twitter, stop putting that on Twitter. So they kept tagging her in tweets to try to get Ingrid's attention. And then they basically, like, Ingrid had to like do a 180 on that and be like, okay, I take that back. Don't spit on them. They're going to get what they deserve. They're going to get what's coming to them. No reason to spit on them. These are the kind of other social media posts. So that when so you might have noticed that it sounded like the last two paragraphs that he was about to say, well, it looks like Scientology actually is correct. These were part of the public conversation or public interest. Talking to a reporter, that's public interest. These social media posts, that's public interest. Well, he's about to rule against them anyway. He's like, yes, you've met you've met one of the prongs, but you haven't met all of the prongs. So, yeah. So we're gonna revisit that issue in a moment. Oh no, I guess I forgot to tell you guys. This woman, Ingrid, she is a Scientologist who used to work in Scientology's Guardian's office prior to the existence, what is now Scientology's Office of Special Affairs. The Guardian's office is the Scientology entity that perpetrated the largest ever infiltration of the United States government. Ingrid is also worked at an executive at one of the most well-known Scientologist-run companies, Executive Software. I think it used to be called Diskkeeper. It either used to be called Diskkeeper and it's now called Executive Software, or it used to be called Executive Software and it's now called Diskkeeper. In any event, it's run by Craig Jensen, who himself used to be a member of the Guardian's office. And this is the person who's on Twitter telling Scientologists to spit on the Jane Does. I don't know. I guess someone that would be stupid enough to try to infiltrate the government is also someone to be stupid enough to be like, a spit on the Jane on Twitter. And then Scientology has to rein them back in. That's the kind of incredible activity and harassment that the Jane Does have been subjected to by Scientology agents. And okay, the next part that I wanted to share with you, I'm pretty sure it is. Let's see, this page is what? That's 15. I wanted to share with you 14, which I already did. Thank you. Here, I won't make you guys watch me scroll. The next one I wanted to go to, we're going to skip the stalking. We're going to go to page 17 on this. All right. Here we go. All right. The more appropriate question. Okay, here we go. The more appropriate question at this stage is, could each of the allegations in the paragraphs that met prong one, viewed in context, be used to create liability for stalking? The answer is in the affirmative. In fact, these allegations can support several different elements and sub-elements of stalking. Okay. Hold on, guys. As Lopez instructs, blogs, messages, letters can constitute a credible threat, a pattern of conduct, and harassment depending on the context. Considering the entire factual context and the reaction of the plaintiffs, The blogs of Heather Seidler, Virginia McGregor, Kathy Gold, and unknown persons could be perceived by the plaintiffs as part of a course of conduct that implies a threat, constitutes harassment, or all those factors. Significantly, these acts occurred during the time span when each plaintiff was subjected to a bevy of other acts of harassment following publication of their accusations against Danny Masterson. Moreover, the behavior viewed along with all the persistent harassing behavior could seriously alarm, annoy, torment, or terrorize a reasonable person. The conduct revealed an obsession by individuals or a group with plaintiffs centered around charges plaintiffs made against Danny Masterson. And again, most curiously, after the allegations became public. The same analysis can be applied to Miskovich's alleged attempt to shape a reporter's narrative by discrediting an accuser. In sum, plaintiffs have met their burden to show that paragraphs, blah, 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 have minimal merit. Okay, good. I think I'm going to skip the intentional infliction of emotional stress section, and we are going to go right to the section about conspiracy. We've been hearing a lot of that word recently in the motions and the rulings in the lawsuits against David Miscavige and Scientology. I kind of like it when judges weigh in on the subject of conspiracy. Okay. And here we go. Vicarious liability. In their moving papers and in oral argument, defendants assert that even if this conduct could support a cause of action, defendants are not liable because Heather Seidler, Virginia McGregor, Kathy Gold, Michelle Miskovich, oh, they spelled it differently there, Michelle Miskovich, and unknown protesters on social media sites, these parties are not agents of defendants. While it is certainly questionable whether plaintiffs have established an agency relationship, there is another theory of liability advanced by plaintiffs: conspiracy. When conspiracy liability is alleged, each member of a conspiracy is liable for all acts done by co-conspirators in furtherance of a conspiracy, with vicarious liability continuing until the conclusion of the conspiracy. The elements of liability under conspiracy are: 1, formation and operation of the conspiracy; 2, wrongful conduct in furtherance of the conspiracy; and 3, damages arising from the wrongful conduct. The plaintiff must establish that the conspiring defendants knew of the wrongful plan and agreed expressly or tacitly to achieve it. That was an amazing paragraph. We're going to read this next one. The most telling sentence of Spencer states, due to the secret nature of conspiracies, their existence is often inferentially and circumstantially derived from the character of the acts done, the relations of the parties, and other facts and circumstances suggested of concerted action. Stated otherwise, the elements of the conspiracy can be inferred from the character of the acts alone. What is clear is that all the activities of the actors shared a similar characteristic. First, they all occurred after plaintiffs' accusations against Danny Masterson and the ensuing LAPD investigation were publicly revealed. Second, the content or context of the attacks shared comparable features. Each actor either directly attacked the plaintiffs about their accusations of sexual misconduct at the hands of Danny Masterson or their victimization by defendants, or was similarly harassing that coincidentally occurred after plaintiffs' accusations against Danny Masterson and the other defendants became public. This alone is sufficient to satisfy the minimal showing that a conspiracy in fact existed and that individual actors who engaged in similar conduct were co-conspirators. To be clear, Heather Seidler, Virginia McGregor, allegedly inciting fellow Scientologists to assist in harassing plaintiff Bixler, Michelle Miskovich allegedly contacting a reporter to suggest that plaintiffs were fabricating their claims, Kathy Gold's many posts attacking plaintiffs, and unknown posters posting false reviews about one of the plaintiff's businesses, and Jane Doe number 2 engaging in criminal activity share sufficient characteristics to demonstrate both the existence of and a participation in a conspiracy. As such, plaintiffs have satisfied their burdens as to the second prong. Conclusion: for the foregoing reasons, the court decides the pending motion as follows. All 4 special motion 2 strikes are denied. Boom. That wasn't too painful, was it? We've only been going for 25 minutes. That was pretty good. This was an utter smackdown. Now, I know a lot of you guys haven't seen all my other videos, but the video I did a few days ago about the hearing itself, one of the things I said, based on what the judge had said, the teams in this lawsuit were showing up for a hearing that wasn't supposed to be about this ruling. It was supposed to be about arbitration agreements. It was supposed to be about something else. The judge has had this ruling ready to publish for over a month, and he could have just published it if he wanted to. But instead, he waited for both teams to show up for a different hearing in the same case and said, surprise, we're not going to be talking about that today. We're going to be talking about my ruling. He could have just published it, but instead of publishing it, he waited for them to come in and he said, oh, we're going to talk about it because I'm basically going to embarrass you in front of everyone here and not only tell you that I'm going to rule against you, I'm going to tell you why, and I'm going to tell you to your face, and I'm going to explain to you how much you've messed up. The judge didn't have to do that. And so we've just kind of been biding our time waiting for this thing to officially be published. Because even at the end of that hearing, the judge was like, I've got a few other tweaks. I just got a few little tweaks I need to make to it, and then I'm going to publish it. And now we've got it. And now you can see just how severe it was. Now, I don't happen to think that Scientology cares about the fact that they're going to be paying many hundreds of thousands of dollars in legal fees. I think Scientology happily pays those attorneys' fees, cost of doing business in order to try and delay. And I still do expect that they will try to appeal this decision to the appellate court, the California Supreme Court, the U.S. Supreme Court, if that's even possible in a case like this. I just honestly don't know. They will keep appealing. The good news is the plaintiff's lawyers are just taking that money, just going to be taking that money. All right. So that's it, guys. That's the ruling. Just wanted to share with you the fun parts. And don't forget, in the video description, I have posted the link to the full document if you guys want to read the whole thing for all you law nerds out there. Let's see. Ken's channel has a super chat here. My nearly a lawyer friend, Aaron, who stayed in a Holiday Inn Express legal update. Your legal updates are getting pro-like. New channel. Thank you, Ken. I appreciate that. No, I would never get out of my lane on this one, but I do have fun reading these documents. Ed S., did you see that Diddy hired Sean Hawley? No way. Man, Sean Hawley gets all the juiciest clients. Okay, so the same attorney who represented Danny Masterson is now representing Puff Daddy, P. Diddy, Sean Combs. That is incredible. Wow. She was also representing Trevor Bauer, the baseball player. Mrs. Massey, new member for the channel. Thank you very much. Welcome. All right, guys, that is it for me this evening. Thank you for hanging out with me, as always. Thank you to everyone who watches until the very end, and I'll talk to you soon.
Okay, if you want to see my rock and roll songs, click right on this guitar. And if you want to see a different one of my videos, then you could click right inside here. If you have subscribed or not,